And so in this chapter, chapter 9, we're going to complete our discussion on the cost of labor contracts by discussing the remaining issues that are negotiated as part of the CBA that include job security and seniority. And the chapter is lined out by defining what job security is and talking about that, about the idea of seniority, how we calculate seniority, what the role promotions play with respect to job security and seniority, the idea of layoffs and recall rights and what those are generally, and some issues around the negotiation of those in union contracts, this requirement for an advance notice of a shutdown, and then determining ability as a separate section. We also want to talk some about company mergers, employee teams, successorship, employee alcohol and drug testing, social media usage, and public sector security issues. And so over the years, workers' interests and demands regarding job security have never waned. Together with wage and benefits, union negotiators view job security as a top priority in both good and bad economic times. Many view job security as simply meaning the guarantee of a job. However, in reality, it's much more. It also entails the rights to remain employed during times of layoffs, rights to promotional opportunities, and to fair hearing in cases involving discipline, as well as the need to have work performed by employees within the company rather than subcontracting or increasing the use of automated equipment. And so this concept of job security has also been termed industrial jurisprudence. This concept contains the primary ingredients of job security in today's collective bargaining, those being seniority as a determining factor in layoffs, promotions and transfers, control of entrance to the organization or trade, seniority as a determining factor in job assignments, negotiation, management change, and work methods and introduction of new machinery and negotiated wage rates. Essentially, this system of rules and regulations that labor and management fashion to determine their specific employment rights and obligations in the workforce. The ultimate labor management conflict over job security is a basic and important one. Management believes that it needs to have a free hand in the operation of the workplace to maximize profits and exercise its abilities. Of course, in contrast, labor believes that employee experience and skills are critical to productivity. Employees require some protection against unreasonable managers, as well as guarantees that important decisions, such as promotions and layoffs, will be made rationally and that favoritism or union busting will be avoided. And so here we talk of this, the ultimate labor management conflict is management believes they need a free hand in the workplace operation. Labor requires protection against unreasonable managers and a voice in decision making. So we see listed here some theories used to justify staffing decisions that are based on seniority, right? And seniority systems include a set of rules and procedures within an agreement that determine the allocation of certain job situations, including promotion, layoff, and recall, as well as certain economic benefits based on length of service. And this is often deemed eligible or reasonable practice under human capital theory, implicit contract theory, and internal labor market theory. And we see here that larger unions are able to negotiate more job security provisions. And so this table, table 9-1, types of job security provisions in contracts on page 325, just talks about the percentage of employees who are covered under one or more of these types of job security provisions in contracts. And so these are something like layoff and recall rights that are focused on who gets laid off first when a layoff occurs, or who is recalled first when a recall happens at a company, and those are tied to certain concepts around seniority. And so this just gives us a feel for the percentage of employees, all employees by industry between manufacturing and non-manufacturing, or by the size of the bargaining unit. And so again, we said that the seniority system is a set of rules governing the allocation of economic benefits and opportunities on the basis of service with one employer. It is by far the most commonly negotiated means of measuring service and comparing employees for promotion and layoff recall decisions, thus providing job security. Seniority is perhaps the most important measure of job security to employees, and the issue of seniority is popular among unions as viewed as critical to job security. It's highly visible because it's so easy to define and measure, and it's normally calculated in terms of days beginning with the employee's date of hire, and with few exceptions continues over the years during the employee's tenure. And so we see here that seniority is not required by law, nor is an inherent right of employees. It is a mandatory subject of collective bargaining, however. Management may argue that time worked on the job is only one measure and the employee's performance record should also be considered. However, performance appraisal systems often depend heavily on supervisors' objectivity and ability to evaluate individual performance honestly and thoroughly, which is often difficult. In general, seniority is considered to be the process of giving preference in employment decisions on the basis of length of continuous service with the company. When seniority is involved in promotional considerations, it may be defined as preference in employment on the basis of the length of continuous service and the ability and fitness of the employee to perform a new job. New employees generally begin acquiring seniority on the date they're first hired. In the case of two or more employees hired on the same date, the exact time of hire or the alphabetical listing of their last names may determine seniority. Often, however, seniority is not awarded to employees until after a probationary period, even though they began accruing seniority for their first date. The contract clause that specifically defines security can be fairly detailed. Most agreements require the company prepare and post a seniority list so there will be no question about employee, department, or plant-wide agreement. The seniority list is a common company list used to identify employees in the bargaining unit according to their length of continuous service. There must be total agreement as to the exact calculation and order of employees on seniority lists. The method of displaying seniority lists is usually a matter for local negotiation between labor and management. And so depending on the particular contract agreement, seniority rights are vested within a variety of employee units. The most common unit is the plant-wide security, in which an individual employee receives credit that becomes applicable whenever the employee competes with any other employee from any other unit for the same position. Other common seniority includes departmental, trade, classification, and company-wide. In the departmental seniority system, employees accrue seniority according to the amount of time they work in a particular department, and that seniority credit is valid only within that department. Classification seniority is similar to departmental seniority, and it provides for employee seniority only within the same job classification. Company-wide seniority systems combine all employees from various locations and types of facilities. When two employees compete for an open position on a company-wide system, individual experience, length of service, and related departments or job classifications are not considered, only the seniority with the company. And then we talk about this idea of bumping, which is prevalent in 63% of all collective bargaining agreements. Bumping occurs when employees with greater seniorities whose jobs have been phased out have the right to displace workers with less seniority. Most bumping clauses require that bumping employees be as qualified as the junior employee. And so an example of this would be, in one case, an arbitrator denied a more senior employee the right to bump a junior employee because the agreement specified that to bump another employee, a person must be qualified to perform the work. The senior employee had been fired for poor performance and then reinstated. So when he tried to bump a junior employee, the company denied his request. And so, in a historic decision, the Supreme Court ruled that employees are not entitled to a job assignment as a reasonable accommodation of his or her disability under the Americans with Disabilities Act, or ADA, if the assignment would conflict with the rules of a seniority system. The decision in U.S. Airways Inc. versus Barnett supported seniority systems when they are in conflict with the ADA in a similar situation. Union officers and committee personnel may be given preferred seniority rights for payoff and recall situations. This is often referred to as superseniority. It's granted to the collective bargaining agreement so that union stewards and other labor officials will continue to work during periods of layoff, thus enabling the union to continue to operate effectively. And so essentially this special seniority, superseniority is this, are these special seniority rights granted to union officers and committee personnel that override the ordinary seniority rights during layoffs and recall situations so that as to maintain active union representation within the company. Management often disagrees with the use of seniority as the sole factor in promotion decisions. The Bureau of National Affairs estimates that seniority is a determining factor in promotional policies as provided by collective bargaining agreements in 67% of labor contracts. However, only 5% call for promotion decisions based on seniority as the sole determiner. Managers may also argue that making important promotional decisions solely on the length of service takes away employee incentive. Employees will tend to perform at the status quo, knowing they cannot be promoted before all the senior employees, and that when their turn comes, no one can take the promotion away from them. Labor leaders point out that seniority can be measured objectively and easily. Therefore, promotion decisions based on seniority are far less subject to supervisor bias or the inability to assess individual performance and skills correctly. And so we see here that most labor agreements use both seniority and qualifications jointly to determine promotions. It's difficult at times to determine the weight of each factor, so how much does seniority play into the decision and how much do qualifications play in the decision. And it's also difficult sometimes in measuring the skill or qualifications of workers, and so it's important to have some agreed to method for measuring skill. Arbitrators have generally held that management has the right to judge, weigh, and determine qualifications as long as the methods are fair and non-discriminatory. However, if a clause provides that seniority alone is the deciding factor, then management cannot promote a better qualified person if a senior employee is capable of doing the work. When ability and seniority are equal factors, arbitrators generally allow management the right to make the selection, subject to a union challenge that a decision was unreasonable, capricious, arbitrary, or discriminatory. It's quite common for the job bidding process to be detailed in the labor agreement to minimize misunderstandings and grievances and to increase employee morale. The process of a company posting notices of new job positions to give permanent employees the opportunity to apply is what job bidding is. Bids are based on plant seniority and competency and fall into three categories. That's up bid, that's a bid from a lower to a higher pay grade. Down bid is a bid from a higher to a lower pay grade, and lateral bid is a bid from one classification to another classification in the same pay grade. And so agreements often specify seniority as the sole decision criteria in layoff and recall situations. Contract provisions that specify how seniority, ability, and other factors will be used to determine the order of employee temporary job layoffs and job recalls are what we refer to as layoff and recall rights. Employers may argue that ability should be a greater factor in determining layoff and recall of employees. However, because these layoff and recall situations are usually seen as temporary, management's argument against the use of seniority is considerably weakened. Also, in these layoff and recall considerations, there's less of a question of the employee's ability because he or she had been performing on the job satisfactorily before the layoff occurred. So management has little room to argue that seniority is a more valid criteria in layoff and recall than in promotional decisions. In most labor contracts, probationary employees are laid off first, with further layoffs made in accordance with plant-wide seniority as necessary. Laid-off employees may be given the opportunity to exercise their plant-wide seniority and bump employees at the bottom of the seniority list rather than be laid off. And so contract procedures may fall into 4 general categories with respect to layoffs. The layoff could be based entirely on seniority. The layoff could be based on seniority among those employees who management feels are capable of performing the work. The layoff may be based on seniority only if ability and other factors are equal among affected employees. And the least common criteria is that the layoff may be based on past performance. And so regarding seniority rights involving layoffs by companies or governmental agencies subject to court order affirmative action plans, the Supreme Court in Firefighters Local Union number 1784 versus Stotts upheld a seniority system even though the resulting layoffs adversely affected blacks hired under a consent decree to remedy past discrimination. The court would not allow the consent decree, which had not dealt with the layoff issue, to be given preference over a collective bargaining seniority system. Labor leaders generally defend the protection afforded by seniority systems as necessary to preserve a basic negotiated job right. They argue that changed hiring practices, giving women and blacks more job opportunity, will eventually lead to their seniority in the various systems. Increased employment and secure job rights will accomplish the desired affirmative action goals without adversely affecting the senior worker. So in 1988, the Worker Adjustment and Retraining Notification Act, or WARN, was passed. The general purpose of the law was to warn workers and local communities of plant closing or mass layoff decisions by requiring employers to provide advance notice in either situation. This was strongly opposed by the U.S. Chamber of Commerce. However, corporate officials at companies such as Ford and Eastman Kodak and Whirlpool and other companies noted that WARN mandates less notice than most firms have voluntarily given workers. The Act requires employers to provide 60 days advance written notice of either a plant closing or a mass layoff once the decision is made by management. A plant closing is defined as the permanent shutdown of a single site or one or more operating units that causes an employment loss of 30 days or more for 50 or more employees. The law requires written notification when other employees remain working if 50 or more are included in the shutdown. Advance notice of a temporary shutdown decision is required if the action affects for more than 6 months at least 50 employees and 33% of all employees, or whenever 500 or more work employees are affected. Advance written notice of 60 days or more is also required when mass layoff decisions will affect at least 50 full-time workers and 33% of all employees, or whenever 500 more are affected. And so obviously there are some very detailed and succinct rules around this WARN requirement, and I encourage all HR staff to be well aware of what these are, because they sometimes can just sneak up on you in the throes of having to make some of these difficult and hard decisions. In general, the burden of proof is placed on the employer to show that a bypass senior employee is not competent for a job during promotions or layoff or recall actions. However, employers are not required to show that junior employees are more competent. When seniority and ability are given practically equal weight in contract clauses, arbitrators expect the employer to prove whether the ability factor is given greater weight than seniority factor. In general, even though arbitrators may speak in terms of burden of proof, when management's decisions regarding a passed-over employee's ability is challenged, both parties are expected to produce any evidence supporting their respective position. And these are some of the criteria used to determine employee ability. And obviously they make sense when we talk about, so what's the employee's experience? Is there a trial period? That's a trial period that can be invoked. What is the opinion of the employee's supervisor, their educational background and production records? What have they done today? Their attendance records. Have they been at work on time every day? Are they constantly out? Discipline records. Have they been a troublemaker? Have there been constant grievances or violations of union contract clauses? Their attitude, physical fitness where it may matter as it relates to the job. And then employers may also elect to administer a type of test that's meant to gauge a particular ability or skill set. So when separate companies or different entities merge, how the seniority lists of the two are combined becomes a critical question. The merger must specify which principle of combining seniority lists will be used. Over the years, mergers have utilized at least 5 common methods of combining the seniority list of merged employees. One of the most commonly used methods is the surviving group principle. And in this method is one in which seniority lists are merged by adding the names of the employees of the acquired company to the bottom of the acquiring company. Thus, all of the employees of the acquiring company receive greater seniority consideration than any employee of the acquired company. Another method, the length of service principle, is used when an employee's length of service is considered regardless of which company he or she worked for before the merger. With the follow the work principle, the employees are allowed to continue previously earned seniority on separate seniority lists when their work with the merged company can be separately identified. The absolute rank principle gives employee rank positions in the merging seniority list equal to their rank position on the prior seniority list. Therefore, 2 employees are ranked first, followed by 2 ranked second, followed by 2 ranked third, and so on. And finally, the ratio rank principle combines seniority lists by establishing a ratio based on the top number of employees in the 2 groups to be merged. So if Group A has 150 employees and Group B has 50 employees, the ratio is 3 to 1, 150 to 50. And the first 4 places on the new seniority list, the 3 ranked highest in Group A, are given positions 1, 2, and 3, and the highest ranked position in Group B are given rank 4. Any one principle, especially length of service, may be selected, or a combination of the methods may be used to combine seniority lists of merged units or companies with weight given to the different principles. So a few problems arise when there are specific contract restrictions on management's ability to subcontract. Management's insistence on freedom in this area often leads to grievances. A grievance over a management right to subcontract or outsource work during the agreement often results in arbitration. In the past, many arbitrators held that management has the right to subcontract work through independent contractors. However, in recent years, arbitrators have been somewhat restricted in this practice. So when we talk about what is subcontracting or outsourcing, it's really an arrangement by the employer to have another firm make goods or perform work that could be accomplished by the employer's own bargaining unit employees, usually because the subcontracted work can be done for more efficiently or less cost. We also have to keep in mind this scope clause, which is a provision that prohibits outsourcing bargaining unit work while any union member is in a layoff status. Outsourcing as a threat to job security is a threat to many unions today. And so a large portion of the work within most organizations occurs within groups. Most jobs do not exist in isolation, but instead involve both formal work groups, that is departments, sectors, and such, and informal work groups of employees whose strong friendships affect their working relationships. The effectiveness of these employee teams can be critical to the success of the entire organization. And so when we talk about employee teams, we're talking about employee involvement that creates an environment in which people have an impact on decisions and actions that affect their workplace, not the terms and conditions of their employment. Characterized by workplace decisions making by truly empowered, intact employee teams for whom managers provide consultation and assistance in how the work is to be done. It's believed that when the group develops a successful working interaction, synergy occurs and more can be achieved as a group than the members could achieve working individually. This enhanced productivity may be evident in areas such as decision making, such as problem solving, and in creativity. And so successorship refers to the status of the collective bargaining relationship between an employer and the union when a change in the ownership of the organization or a change in a union occurs. If there's a change in either of these, then an unexpired collective bargaining agreement may not be certain of their status. The situation may exist when the union becomes decertified because of a schism, merger, or change in union affiliation, or if the union simply becomes defunct and is replaced. Changes in management can occur when the sale of all or part of a business occurs because of a merger or corporate consolidation, or if the corporation is reorganized. The Supreme Court for the first time offered a test for determining the circumstances under which the successorship doctrine applies, and that was in the Fall River Dine versus the National Labor Relations Board. The court in its decision suggested 3 factors must be present for the successorship doctrine to apply to the purchaser of a business employing union members. One is substantial continuity, and the successor substantially continues the business operations of the predecessor. Factors considered include the purchase of real property, equipment, and inventory, employing workers on essentially the same jobs, employing the same supervisors, and continuing the successor's or the predecessor's product line. The appropriate bargaining unit. The bargaining units of employees must remain appropriate after the change of employers. Job duties and operational structure are critical in this determination. And then the predecessor's workers. So the new employee hires a majority of its employees from the predecessor. And so, again, when the court has seized these factors, they can invoke the successorship doctrine, which really just says that the status of the collective bargaining relationship between the employer and the employer and the union, when a change in one of these organizations occurs, stays the same. And so when we talk successor-employer rights, we know that the new employer has several important rights even as a successor employer, and they include the right to hire its own workers, although it may not discriminate against workers of the predecessor because of union status. They also have the right to disregard the predecessor's collective bargaining agreement, and they have the right to set the initial terms of employment, such as wages, benefits, and working conditions, without consulting the union. The National Labor Relations Board qualified prior rulings concerning a successor employer's refusal to hire the predecessor employees because of their union status and planned building services. In this case, the board held that if a successor employer could show it would not have hired the employees even in the absence of its acknowledged union animus, it would be guilty of an unfair labor practice. And so the use of alcohol and drug testing of job applications and employees has become a complicated and critically important job security issue. Management often claims that employee use of alcohol and illegal drugs is a problem that must be contained. President Reagan launched a federal government drug-free workplace campaign that started the testing of job applicants and employees. By 2003, it was estimated that about 25 million people in the United States were tested annually, and millions more were subject to a possible test because of an accident or other use or cause. Obviously, the union is concerned about this type of testing because the reliability of the testing, it should be shielded, and there should be high secrecy and protection of employee identity, or biased test if the employee feels that they've been prejudiced by the person who's performing the test, or by any of the people who serve in any of the links along the testing chain. And then there's the whole issue of invasion of privacy. And so here we see that the National Labor Relations Board has ruled that drug testing is a mandatory subject of bargaining. So if one or other of the other parties, as we discussed in an earlier chapter, brings this up as something that needs to be negotiated, the other party is unable to reject the negotiation or to reject it as a term or condition or provision of the CBA. And so as we see here, management's desire to screen all job candidates may increase because of several factors, including the increased use of drugs within all segments of society, the reluctance of previous employers to report suspected or known drug usage of former employees for fear of litigation, and the employer's liability for the negligent hiring of employees. And so because of these different factors, there are 6 common types of drug testing used by employers, and they include pre-employment testing, reasonable suspicion testing, routine fitness for duty testing, post-accident testing, and random testing, as well as follow-up rehabilitation testing, which is done after returning to work from a drug or alcohol treatment. And so obviously management doesn't want employees who are on the job either influenced by drug or alcohol impacts. It creates safety conditions, safety hazards. It could impact employee morale. You can only imagine all of the different issues that come about as a result of this. And so, there are valid concerns on behalf of management with respect to this testing. And we talked about these common types of drug testing: pre-employment, reasonable suspicion, routine fitness for duty, post-accident, random testing, and follow-up rehabilitation. And so then on the other side, of course, we have employee attitudes toward drug testing. Unions' institutional response to drug testing programs originally focused on the struggle over bargaining duties. That is, could an employer institute a drug testing program unilaterally? And then after the NLRB ruled that such policies have to be negotiated, unions were faced with the responsibility of representing their members' views on drug testing at the bargaining table. In the atmosphere created by the federal government's war on drug, less than a strong anti-drug attitude was considered unpatriotic. And so knowing that, unions focused no longer on whether drug testing could be done, but on how it would be done. There are several negotiation issues regarding the probable cause testing process and the use of test results. And these include valid testing procedures where the burden of proof is on management, and questions related regarding the use of confidential, fair, and valid testing procedures. On-the-job impairment issues. There's refusal to be tested. So how does management, what are their options where an employee refuses to be tested? Management can usually sustain the termination of an employee for failure to take a drug test in cases of probable cause. And then there's supervisor training, which is a program that includes the training of all supervisors to recognize the typical signs of employee drug use. And that's important if probable cause is a basis of testing. So a new major job security issue appearing in more newly negotiated agreements is the more disciplined cases, and in more disciplined cases is employees' use of social media such as Facebook, Twitter, and YouTube. Employers in both private and public sectors are increasingly adopting policies to limit the use of social media both in and out of the workplace. The failure to follow such a work rule under many existing CBAs is treated as a case of employee misconduct and can lead to suspension or even terminations. So unions strive to negotiate a specific new contract provision that deals with social media. And so now let's turn to public sector security issues for just a few minutes. As we talked in Chapter 3, public unions and their members are concerned that to lower their personnel costs, governments will turn to outsourcing full-time public sector jobs. In addition to outsourcing, the National Education Association, or NEA, and the American Federation of Teachers have cited school voucher programs as a major concern for a public employee. Critics of public schools have advocated tuition voucher programs which provide families with public funds that could be used for private school tuition, including religious-based schools. Advocates of school vouchers contend that giving families a choice will force public schools to improve to stay competitive. And so, again, when we talk about outsourcing, it's essentially the same concept or concerns in the public sector as it is in the private sector, and which is of great concern to the unions. And we note that the Great Recession of 2008, where public sectors were watching developments around the country as angry taxpayers who have lost their jobs complained about the size and expense of federal government and state governments. And so this concludes Chapter 9 of the dealing with job security and seniority, and it completes Part 3 of what we wanted to talk about with respect to cost of labor contracts. And you'll recall that in this section of cost of labor, we talked about wage and salary issues, we talked about employee benefits, and we talked about job security and seniority. And so I encourage you to be very familiar with each of those concepts and in each of those chapters. And then if you would please move to the discussion forum questions and the assignments. Thanks for your attention.